সকলকে আবারও আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজাম কো সলিসিটর্স, এবং আমার সাথে আছেন ক্রিমিনাল লয়ার স্পেশালিস্ট কিউসি, আমার কলিগ ডেভিড ওয়ালব্যাংক কিউসি। নতুন আইন আসছে আপনার টেররিস্ট অফেন্ডার্স রিলিজ অ্যাক্ট, যেটা 2020। ওইখানে আপনার জাস্টিস সেক্রেটারি রবার্ট বাকল্যান্ড সে বলছে কি যে from today terrorist offenders will only be released before the end of their sentence if the independent parole board is satisfied they no longer pose a threat. সে বলছে কি এখন থেকে তারা শুধু রিলিজ হবে, তাদের যে 10 বছর হোক বা 20 বছর হোক ওর আগে তারা রিলিজ পাবে যদি প্যারোল বোর্ড যদি স্যাটিসফাইড হয় যে তারা সোসাইটির কাছে আর কোনো থ্রেট না, কোনো দে নো লঙ্গার পোজ এ থ্রেট টু দ্য সোসাইটি, and they will face the strictest possible conditions and monitoring upon release, এবং তাদেরকে স্ট্রিক্ট কন্ডিশনে রিলিজ করা হবে এবং তাদেরকে মনিটর করা হবে, এবং ওই সমস্ত মনিটরিং কন্ডিশন এবং স্ট্রিক্ট কন্ডিশন তাদেরকে ফেস করতে হবে যখন তারা রিলিজ হয়। All terrorist offenders will also be subject to robust safeguards upon release. তাদেরকে একটা সেফগার্ডের জন্য তাদের ব্যবস্থা করা হবে যখন তারা রিলিজ হয়, which could include, যেটা ইনক্লুড হয় কি কি, নোটিফিকেশন রিকোয়ারমেন্টস। নোটিফিকেশন রিকোয়ারমেন্টসটা কি? ওইটা হচ্ছে ইট ইজ এ লিগাল রিকোয়ারমেন্ট দ্যাট প্রোভাইডস দ্য পুলিশ উইথ ইনফরমেশন ইউজফুল ফর অ্যাসেসিং অ্যান্ড মনিটরিং রিস্ক। যে পুলিশ তাদেরকে অ্যাসেস করবে, মনিটর করবে পুলিশ তারা মানে কোনো রিস্ক কিনা সোসাইটির কাছে, কমিউনিটির মধ্যে, এটা তারা পুলিশ সবসময় তাদেরকে অ্যাসেস করবে এবং পুলিশের কাছে তাদের সম্বন্ধে বিভিন্ন ইনফরমেশনগুলো থাকবে। এবং অন্যান্য আরও কন্ডিশন এবং রেস্ট্রিকশন যেগুলো ইম্পোজ হবে, যেগুলো রেস্ট্রিকশনস অন ট্রাভেল অ্যান্ড কমিউনিকেশনস, তাদের রেস্ট্রিকশন দেওয়া হবে তারা ট্রাভেলিংয়ের উপরে, এবং অ্যান্ড ইম্পোজড কারফিউজ, এবং তাদেরকে বলা হবে তোমরা হয়তো পাবলিক ট্রান্সপোর্টের মধ্যে তোমরা মানে ট্রাভেল করতে পারবে না। অনেকগুলো ট্রাভেল রেস্ট্রিকশন তাদের উপরে থাকতে পারে বিভিন্ন ধরনের, এবং তাদেরকে কারফিউ দিতে হইতে পারে, এবং তারা বলবে কি যে তোমরা সকাল 8টার থেকে মানে সন্ধ্যা মানে 6টা পর্যন্ত বা 7টা পর্যন্ত তোমরা বাইরে থাকতে পারবা, ওর পরে সন্ধ্যা 6টার পরে তাদেরকে ঘরের ভিতর থাকতে হবে। মানে কারফিউ মানে যে একটা রেস্ট্রিকশন থাকবে তাদের মুভমেন্টের মধ্যে, তাদের ওই মানে ওই টাইমিংটা তাদেরকে তখন ইম্পোজ করা হবে। I will pass to my colleague David Walbank QC to talk more on fraud and money laundering.
Thank you very much indeed, Shafi. Well, what I'm going to try to do in this final segment is really deal very briefly with 3 different topics. The third of the ways in which the main fraud offence can be committed under the 2006 Act, that is to say fraud by abuse of position. I then want to look very briefly at what I've called the subsidiary offences created under that Act, and then finally I will give a bird's eye view, and I mean a very brief summary, of the money laundering provisions and the money laundering offences created under the Proceeds of Crime Act of 2002. So, first of those 3 topics, fraud by abuse of position, the third way in which the main fraud offence under the 2006 Act can be committed. Relatively straightforward, in fact. A person commits an offence if he occupies a position in which he is expected to safeguard or not to act against the financial interests of another person, and he dishonestly abuses that position, and he intends by means of abusing that position to make a gain for himself or another, to cause a loss to another, or to expose another to a risk of loss. So it's abuse of position, specifically a person occupying a position in which they are expected to safeguard or at least not to act against the financial interests of another person. Now, importantly, a person can be found to have abused their position by omission. They don't need to have done any positive act. It can be sufficient for them simply to have failed to do something. That can amount to an abuse of position. And the clear intention of these provisions is to cover dishonest abuse of a position of financial trust or responsibility, including, for example, a trustee, a company director, an executor, but could actually extend to frauds committed by employees, including in some instances where the employee couldn't be prosecuted for theft. They could still be guilty of abuse of position by reason of their employee status and the power that gives them, which they then go on to abuse. That's all I'm going to say about the concept of fraud by abuse of position. Can I then come on, Shafi, to deal very briefly with what I've called the subsidiary offences, the mopping up offences under the Fraud Act 2006. Effectively, it's a series of miscellaneous offences created by the provisions. The first of them is possession or control of articles for use in fraud. A person will be guilty of an offence if he or she has in their possession or under their control an article for use in the course of or in connection with any fraud. So as you can see, there are basically two key concepts. What is possession or control, and what is meant by an article for use in fraud. Well, perhaps rather surprisingly, possession and control aren't actually defined in the Act, but it's pretty clear from a body of authority that's built up over the years in relation to the use of that phrase in other statutes and in other contexts, that it will ordinarily require physical possession or control of the article in question. Not always so. There is one exception where a person has been engaged in a group activity and another member of that group has physical possession or control of the article in question with the knowledge of the defendant. That may be sufficient for these purposes. In other words, constructive possession or control on the basis of possession or control by another member of the group that's committing the fraud. What does article mean? Well, it means the same as I've already touched on this, I think. It can include not just a physical article, it can include a program or data held in electronic form, and it's plainly meant to address the importance of computer technology in the perpetration of fraud in the modern world. So that's the first of the subsidiary offences. The next of them also relates to articles for use in fraud, but it relates to making or supplying articles for use in fraud. Pretty self-explanatory, I think. Another subsidiary offence, the third of them, is obtaining services dishonestly. Perhaps the only point I need to make about this is that this is different from the main fraud offence created under Section 1 of the statute, because this is a result offence, not a conduct offence, as the lawyers would put it. In other words, there does actually have to have been an obtaining of services dishonestly. It's not enough that that's the intent of the defendant. The intention has to be carried into fruition for that offence to be made out. And then finally, in relation to these subsidiary offences, what I think is an interesting addition to the offences of fraud created by the 2006 Act. In effect, there's a section which extends to sole traders and into unincorporated bodies the offence of fraudulent trading in relation to the business of a company. Just taking a step back for a moment, I'm sure you know, Shafi, that under the Companies Act, carrying on the business of a company with intent to defraud either the creditors of the company or the creditors of another person, or indeed carrying on the business of a company for any fraudulent purpose, amounts to an offence. And there is a provision now within the Fraud Act 2006 which effectively extends that offence to sole traders and to unincorporated entities. It was extended by recommendation of the Law Commission, and that has now been done within the 2006 Act. So a number of miscellaneous offences which I've dealt with, which are created within the provisions of the 2006 Act. Now I'm going to try finally, if I may, within the time left to me, to give a very, very bird's eye view of money laundering and the money laundering offences which are created by the Proceeds of Crime Act of 2002. And perhaps the best way I can deal with it in the time available to me is to say essentially that there are two key concepts. First of all, there needs to be property that is dealt with in one or other of a number of specific ways. And secondly, it needs to be shown that the property that's been dealt with in one of those ways is so-called criminal property. So the laundering part of this is effectively dealing with particular property in one of a number of ways. If a defendant conceals the property, or disguises the property, or converts it, or transfers it, or removes it from the jurisdiction, or acquires it, or uses it, or possesses it, or enters into a money laundering arrangement in relation to that property, then he has dealt with the property in one of the ways which is prohibited by the Proceeds of Crime Act of 2002. So that's one of the two elements that needs to be established by the prosecution. The second element that needs to be established in order to make out a money laundering offence is to show that the property in question is criminal property. And it's important to note that that phrase money laundering in a sense is misleading because it's not restricted to money, it's not restricted to cash. It can relate to any form of property. The only qualification, as I say, is that it has to be shown to be criminal property. What is criminal property? Well, under the Act, criminal property for these purposes is property which constitutes a person's benefit from criminal conduct or represents their benefit from criminal conduct, either in whole or in part, and whether directly or indirectly. And it needs to be shown that the person whose criminal property it is said to be knows or suspects that it constitutes or represents the proceeds of the criminal conduct of the other person. It doesn't, importantly, the person who committed the offence which created the property, which generated the property, doesn't need to be the person who's accused of the money laundering offence. In fact, very often the person who's accused of committing the laundering offence will be somebody completely different from the person who's said to have committed the underlying criminal conduct which has generated the property in question. That's the whole purpose of this regime. It's to criminalise those who provide, if you like, freelance money laundering services to those who are committing crimes and wanting to retain control and use of their criminal proceeds. Property is very widely defined for these purposes. It is property wherever situated, and it includes money and all forms of property. And again, somebody is said to have obtained property if they obtain any interest in it. So it's all very widely defined. And then one more wide definition. I've made the point that there needs to be either knowledge or suspicion that the property in question either constitutes or represents a person's benefit from their criminal conduct. Suspicion, again, is very widely defined. The Court of Appeal have interpreted that word suspicion, and they have said that it is sufficient if a defendant thinks that there is a possibility, which is more than fanciful, that the property in fact represents criminal property. That they concede that a vague feeling of unease will not be sufficient, the statute does require the suspicion to be clear or firmly grounded and targeted on particular facts, or based upon reasonable grounds, if you like, but suspicion, something more than mere fanciful feeling that it may be criminal property, suspicion is sufficient. I suspect that's probably all I need to say about the money laundering offences, save perhaps in one respect. I made the point that one of the ways in which the property can be dealt with is if a person enters into a money laundering arrangement in relation to that property. And again, I should finish by saying money laundering arrangement is again very widely defined. A person commits an offence under the 2002 Act if they enter into or become concerned in an arrangement which that person knows or suspects facilitates by whatever means the acquisition, the retention, the use or the control of criminal property by another person or on behalf of another person. So very widely defined, the question of a money laundering arrangement. That was a very, very brief and bird's eye view in the time available of the money laundering offences, and perhaps we'll try and deal with that on some other occasion in a bit more detail.
In the next time, we'll দর্শক ডেভিড ওয়ালব্যাংক কিউসি সে অনেক ফার্স্ট আপনার টপিক এইটার ফ্রড এবং মানি লন্ডারিং উইদিন শর্ট টাইম এটা কোনো সম্ভব না এগুলোর উপর বলা উনি আবার নেক্সট প্রোগ্রামের মধ্যে আসবেন উনি আবার এই টপিকের উপরে ফ্রড এবং মানি লন্ডারিং এর উপর বলবেন আপনার বুঝতে হবে ইজ ভেরি ভেরি ওয়াইড আপনার ওয়াইড এরিয়া অফ ল আপনার অনেক সময় এখন আমাদের কিন্তু মানে যারা সলিসিটররা আছে তাদেরও কিন্তু মানি লন্ডারিং চেক করতে হয় ক্লায়েন্টরা যখন পয়সা দেয় তাদের পয়সার উৎস কি সেটা আমাদেরকে এখন চেক করতে হয় তার মানে তাদের পে স্লিপ নিতে হবে তাদের ব্যাংক স্টেটমেন্ট নিতে হবে তাদের আপনার ইনকাম ট্যাক্স রিটার্নের আপনার কপি লাগবে তাদের যে সোর্স অফ দ্য মানি ওগুলো জাস্টিফাই করতে হয় আমাদেরকে অনেক সময় বলে কি ক্লায়েন্টরা কেন আমি এগুলো দিব এগুলো হলো চেক লিস্ট এগুলো এখন সব লয়ারদেরকে করতে হয় পার্টিকুলারলি কনভেন্সিং লয়ার ক্রিমিনাল ল এবং অন্যান্য এরিয়া অফ ল যারা প্র্যাকটিস করে সবাইকে এই মানি লন্ডারিং চেকগুলো আপনার ফলো করতে হয় আজ আমাদের সময় প্রায় শেষ হয়ে গেছে আজকের প্রোগ্রামটি আবার পুনঃপ্রচার করা হবে নেক্সট তাছাড়া এনটিভি ইউরোপের ফেসবুক এবং ইউটিউবে লগ ইন করলেও আপনারা প্রোগ্রামটি দেখতে পারবেন সবাই ভালো থাকুন সুস্থ থাকুন এবং সকলের প্রতি আমার শুভকামনা থাকলো আসসালামু আলাইকুম